today we want to talk about a trend we're seeing with regard to Article 32 hearings in the military. I was reading some of the most recent articles in the New York Times, in the Washington Post, regarding the Naval Academy football sexual assault trial, and most of the op-ed pieces were talking about how in an Article 32, that initial investigation, that a alleged victim does not have any rights, that the cross-examination of an alleged victim is too harsh on them, and that defense attorneys are just having free reign in Article 32s. And there's been an undercurrent in these conversations about having an Article 32 specifically for sex assault trials, where the defense attorneys and the accused are not even allowed to be present, where essentially a alleged victim can make her allegations, tell her side of the story completely unchecked, and then the case would proceed on through trial because this cross-examination was just too tough on them and that there were no rights for victims. That's what I'm seeing. I completely disagree with all of it, not surprisingly for those of you who follow me. But Mike, what are your thoughts on this trend that we've been seeing in the media on these Article 32s?
Well, Tim, most of the problems that are arising in these cases where the media is saying, oh, this is not fair, these lawyers are too aggressive, they're cross-examining these alleged victims on inconsistent statement, outright lies, confronting them with text messages where the text message completely destroys the credibility of this person. In other words, they're exposing someone for being a liar. And instead of saying, you know what, this person's lying, it's obvious, what the victim advocacy groups are saying now is this is not fair. Why should someone have to explain their story? Why should they have to answer these questions on cross-examination? It's just not right. We should just send this guy on forward to a court-martial, limit his rights to cross-examination, because after all, they're all guilty. And interestingly, the military, the Department of Defense, the military is just backing themselves in corners. And just because someone makes an allegation doesn't mean it's true, as we all know. But what the problem that they really have is with witnesses that have credibility issues. Now, I always tell my kids, should always tell the truth, because the truth never changes. You don't have to remember the truth. You don't have to have your memory refreshed about what happened 3 weeks ago, because the truth always stays the same. That is not the standard that these prosecutors apply when they coach the witnesses and they tell the witnesses what to say, when they try to shape their testimony to give them a better chance of winning. And what happens is, if you have an experienced outside defense lawyer or an experienced military lawyer, defense lawyer, they catch them in these lies and they expose them. That's the way it's always been done. That's the way our judicial system works. That's the way it's worked here and in England for hundreds of years.
And Mike, just to back up, I agree with everything that you're saying. We get the question a lot, what is an Article 32 hearing? And there's some misconceptions, I believe, from clients as opposed to what's an Article 32 versus what's a trial. And essentially, if you are facing a general court-martial, before any general court-martial can go to a trial, and before the charge is referred, remember there's two stages, there's the preferral and then there's the referral, and those are essentially terms of art. It has to go through what's called the Article 32 initial investigation, or the pretrial investigation. In those investigations, the command appoints an independent investigating officer. You notice I put the quotes there, because they appoint an officer. Typically they're a judge advocate, but in the Army they're not. They hear all the evidence that the prosecutor presents, and the prosecutor has the burden of proving by preponderance of the evidence, which is not beyond a reasonable doubt, it's just more likely than not, that these allegations happen. So typically they call the alleged victims, they call some of their witnesses, and the defense counsel and the accused has the right to be there, that we can cross-examine these witnesses to show and to expose if they're lying, if they have motive, if they have bias. All of this is done to expose the truth as to what really happened. The investigating officer then hears all of the evidence, then writes a report and a recommendation which goes up to the convening authority, typically the CG, the commanding general, or the admiral. In theory, the convening authority is supposed to read this, review it, and then make a decision based on these facts whether the charges go forward to a trial or not, the referral process. So the Article 32 is not the trial, it's the initial pretrial investigation. Okay, so that's the procedural posture of it. Now, at these hearings, as a defense attorney, there's different strategies. Sometimes if I know the case is going to go to trial, and I know there's no chance of winning it at the Article 32, I'll keep the cards close to the vest and go stealth bomber approach. and not want to show my side of the story or give up my cards. Other times, I want to go full in and litigate the entire Article 32 and cross-examine and hammer these alleged victims to show that they're lying or that they have motive or they have bias. And so to think that a defense attorney should not be allowed at these proceedings and that an accused should not be able to cross-examine the witnesses against him before a case goes to trial is absurd. And again, Mike, if these individuals, if they're telling the truth, if they're being honest, they're not being coached or manipulated or exaggerating this, then what is there to hide? Like I said, integrity and credibility. As I always say, either you have it or you don't. Either you're credible or you don't. Integrity, either you have it or you don't. So if these individuals, you are going up there telling your story, if you have nothing to hide, you should have no worries about any question a defense attorney might ask you. But the reality is that's not what we're seeing. And so they want to take the accused and the defense attorney out of the equation so that more trials can just move their way forward and go to trial, and so that these alleged victims have more rights, when the reality is they have so many rights as it is and so many procedural protections as it is. And that,
well, Tim, in a case where they call a victim, and it doesn't even have to be a sexual assault case, but since we're talking about sexual assault cases, I'll address that specifically. When someone is actually a victim of a crime and they come in to testify at the Article 32, and the defendant listens to the testimony, and the witness is straight up, not lying, tells exactly what happens, has great excellent credibility, that defendant is much more likely to try to cut a plea deal because he knows that he's wrong, that he committed a crime, and that he's going down because he sees the person comes in there and tells exactly what happened. And I've seen many cases where someone is an actual victim of a sexual assault, comes into court, looks at the guy and says, here's exactly what happened. He grabbed me, he did this, he did that. Same story from the beginning till the end. Bottom line is he did it. That's him right there. And it's very powerful evidence. What we're talking about is where someone is blatantly lying or exaggerating or not wanting to tell the truth, maybe that they had an affair or that they went and slept with their best friend's boyfriend and they don't want to admit it. So what they do is they get caught in these webs of lies. Then they get hammered and confronted with the lies, and that's what they don't like. And that's what these advocates don't like, these victim advocates. By the way, the victim advocates make money off these cases because they are suing the government and suing different individuals and also trying to make a name for themselves as victim advocates. They're basically tort lawyers. So they tend to exaggerate and push their agenda forward. And one day with the hopes of being able to sue the government successfully, although they've not been able to successfully do that, and get millions of dollars on behalf of these victims, of which a lot of them will take 35% to 40%. So those are the people who we're talking about, these lawyers that are not really even parties to the case. They're just trying to get involved and push their agenda. But
yeah, and that's the issue. Again, if you've got someone who testifies that they were so drunk they were blacked out and couldn't consent, but you have text messages that your client provided you where the entire next morning they're texting, they're talking the entire night, or you've got a video showing their complete sobriety, and you know they're lying, you can prove it, well, that may be a painful process for them, and it should be. Because if you're going to come into court, raise your right hand, take an oath, and lie in order to cover yourself, it should be a painful process to be exposed as a liar. That should be a painful process. But as you said, we don't want that in the military because we want to show we're taking a stand on sexual assault. So once the special victim prosecutors, the prosecutors get involved, the witnesses get coached, they get their handlers, their paparazzi, and they get put through this machine to make them look like they're so victimized. They don't want to get exposed because it makes everyone look bad. And so they're trying to cut that out. And at the end of the day, we're cutting out the constitutional rights of an accused. To what end? At the end of the day, the way I remember it, you're still innocent until proven guilty, although I'm starting to disagree with that in the military. If you're accused of sexual assault, you're pretty much guilty until you can prove yourself innocent. And that's a real problem and a trend that we need to get reversed quickly before it's too late here, Mike.
Tim, I completely agree with you. I mean, some of these prosecutors and the paparazzi, as we call them, which are the victim advocates, the SARCs, their liaisons, their special victim counsel, all these people, like 10, 15 people sometimes that surround the victim. And a lot of these people are not even real victims or liars. And they surround them. I've seen them even take witnesses, and as you we all know they coach them, but the other thing they do is they dress them in a certain way. So you get someone who's dancing on a pole on a Friday night and, you know, giving lap dances and hand jobs for $5 on the weekends. They know that that person has credibility issues, and so they try to keep that person's background out. And then the other thing they do is they dress them up. They dress them up like they're like an innocent little school teacher. And I've seen them put pigtails in girls' hair, tell them to go buy glasses, so they have a better chance of convincing the jury that they're a liar. But the bottom line is, how do you determine if someone's telling the truth? You confront them with the facts and with the evidence. That's how it's been done. That's how it's going to be done. That's how it should be done. And you do that by asking them questions, not yelling at them and attacking them. You ask them questions, and if they can't answer a question or they can't explain something that common sense says they should be able to explain, such as if you were so drunk and passed out and you were not able to even to open your eyes, how were you text messaging all these long text messages from the time that you had sex until 10 o'clock the next morning talking about hooking up with another guy? Was it someone else who was texting, or was it you? If it was you, then you're lying because you weren't passed out. Now, when confronted with that evidence, then that can tend to be embarrassing. Calling someone a liar can be embarrassing. Proving that someone is an absolute liar and a perjurer is pretty embarrassing for the liar. And it's
know what should be embarrassing, Mike? What should be embarrassing is knowingly putting up an alleged victim to perjure herself against an innocent service member, all to up the numbers in war on sexual assault. That should be embarrassing.
And that's not only embarrassing, that's illegal, and that's against everything that you swear to uphold, not only as a service member, but as an attorney. You can't do it, you shouldn't be able to do it, but I see it happening all the time.
So the bottom line with this is the Article 32 is an adversarial process. The Article 32 should not just be a speed bump on the way to trial. And if you have an alleged victim who is telling the truth, who is being honest, who has not been coached by either her attorneys or her paparazzi or her handlers, they should have no problem whatsoever answering a defense attorney's questions. Because as you said, the truth is short and lies are long. And you always remember the truth. And at the end of the day, if they're cross-examined, they should be able to have the straight, honest answers, and the case should go to trial. And if someone did commit sexual assault, as we put from day one, I'm completely opposed to sexual assault. Real sexual assault, it's out there, but the stuff I see in court-martials is not, in the vast majority of cases. And these are great tools to vet out the garbage, and so the garbage doesn't go to trial. And we need to keep that system intact. Defense attorneys should be allowed to cross-examine witnesses fully. Victims should be cross-examined. Again, the truth should come out. If the case merits it, it should go to trial, and the jury will make the right call. If it doesn't, don't send it forward to trial, and perhaps we won't be wondering, why do we have so many acquittals right and left? Because garbage goes to trial. And that's the bottom line here, Mike.
All right, Tim, that wraps up this episode. Until next time, I'm Michael Waddington.
I'm Tim Bilecki. Take care.
Out.